Believe recording has started. I'm gonna wait for Alex to get back in.
I'm here.
Okay. All right. Oral argument is set for 90 minutes. To the extent possible, I'm going to try to follow complainant's requested issue by issue format. We're going to start with the first issue that I put out in POR 19, which is which party bears the burden of proof on the third element of a 39 USC 403C claim. In other words, that element, there's no rational or legitimate basis for denying the complainant the more favorable service currently being provided to those similarly situated postal customers. So, Sai, I'm going to start with you. Oh, I think we maybe lost you again. I can't hear you, Sai. There we go.
There. Sorry about that.
No problem.
May I ask that you request the Postal Service not to give an argument, but just to state its position so that I am not wasting time arguing something that might be agreed or talking past whatever their position is.
I'm happy to let the Postal Service start this issue first. If that's
I would like to go
preferable
first.
to
I just want a statement of what their position is. That's all.
I think that's going to be their position is going to be given during their allotted time.
Understood. So the DC Circuit's decision in Gamefly v. PRC compels the answer to this question to be that in the first instance, you, that is to say the Commission, have the burden of proof in order to survive arbitrary and capricious review. And therefore, the Postal Service has the burden of proof to you. The Postal Service claims that the complainants have the burden of proof to prove what the Postal Service's justifications are, and furthermore, to prove that those justifications are undue and unreasonable. However, its own citation to Edwards Order 7552 contradicts its claim. Edwards expressly held that the burden of proof is not on the complainant and is instead on the Postal Service. That order is in turn based on Gamefly Order 718, which set the modern precedent on 403C standards in the Commission. Aside from one poorly written paragraph in Order 718, that order is very clear that the Postal Service has to prove both what its justifications are and that they are sufficient, that is, that they are both due and reasonable. More importantly, the DC Circuit's holding in Gamefly compels it because it says that the Commission must, wherever it finds any discrimination / preference, either A, fully remedy all such discrimination or preferences, or B, justify as due and reasonable. If there is no justification, or if the evidence for justification is equivocal, the presiding officer is required by law to rule in favor of the complainants. In this case, unlike in Gamefly, which the Postal Service lost at every stage of 7 years of similarly unnecessary litigation that it should have conceded in pre-filing negotiations, the Postal Service has given no reasons at all for nearly everything complained of. It is said explicitly that it has no discretionary authority whatsoever to make policy decisions on anything that we complained about, and that it has made no policy decisions. It's only claimed to be compelled by legal obligation for a minority of what we complained of. Those claims are wrong because the Postal Service claims that it is merely precisely mirroring the legal obligations in the regulations, but they are not an exact match for the text of the legal obligations, and they're not even internally consistent. No matter how deferential the Commission may be to Postal Service reasoning, it cannot defer to reasons that simply do not exist. Now, if you would like, I can explain more about Gamefly v. PRC. I believe that another way of considering the question of burden of proof is that it is equivalent to asking who wins if there's no showing at all. In every Commission decision and in every case law example that I've been able to find, every single time the Commission has found that the evidence was neutral or that it was equivocal, including in Gamefly Order 718, for about half the justifications. The other half are just outright held in favor of Gamefly. Every single time when it's equivocal or it's unsure, the Commission and the courts have held in favor of there being 403C discrimination. There is one paragraph in Order 718, which I will agree is poorly written. That paragraph has been cited by later Commission rulings as setting out the standard, and that paragraph does say that Gamefly has to show it. However, if you read the immediately preceding text, if you look at the Commission analyses of the justifications offered by the Postal Service, and if you look importantly at the actual holding conclusion paragraphs, it says very explicitly the Postal Service failed to show that its reasons were justified. I will also add that there is one other order, 5491 in C2020-2 Greeting Card Association. That order also repeated the misstatement in that one paragraph 718. However, that order found that in the circumstances of that order, the burden of proof did not matter. And so that was simply an uncareful order. We will ask that the presiding officer, in order to clarify Commission precedent, make an explicit ruling on this. But I believe that essentially addresses the question. If you have any questions, I would be happy to answer them.
Thank you. I appreciate it. Alex?
Sure. Allow me to briefly say that, getting to my section here. Although the Postal Service opposed the motion which gave rise to this oral argument, it offers its thanks for the chance to respond to the five items you identified in POR number 19. In a moment, Mr. Presiding Officer, I will directly answer your question, and there is an answer to the question upon which the Presiding Officer is constrained to follow Commission precedents. It bears discussing first, though, that the question of reasonableness would only come into play were the Presiding Officer to be considering discretionary policy decisions that could be judged against a reasonableness standard. This case is different than typical 403C cases in that there are objective external legal reasons for each relevant difference between domestic and international FMFTB. The Postal Service merely serves as a conduit for the relevant policies. The reasonableness of those policies could be raised with the entities that create them, namely Congress, the Universal Postal Union, and foreign nations, which dictate the parameters communicated in the individual country listings within the IMN. That said, turning now to the question the presiding officer has asked. Repeatedly, throughout the Commission's 403C case law, the Commission and its appointed presiding officers discuss that it is a complainant's burden, not the Postal Service's, to establish all three prongs of a 403C complaint case. Notably, on September 19th, 2024, in order number 7552 at page 37, issued within docket number C2023-6, complaint of Mark Allen Edwards, the Commission stated that it, quote, adopts the presiding officer's intermediate decision in its entirety, including its findings of fact and conclusions of law. The underlying intermediate decision simply restated uncontroversial established law regarding the 403C burden of proof, which is borne only by the complainant. The intermediate decision is incorporated and restated in its entirety within order number 7552. On
Sorry,
pages,
Alex, I just wanted to stop you and ask what page on the POR is that burden of proof?
Absolutely. On pages 14, 15 of the intermediate decision, which again is, it's sort of like an addendum to order 7552. So the presiding officer need only go to order number 7552 and scroll down.
Thank you.
Can I ask 14, what page of 7552, just for clarification?
It's on pages 14 and 15 of the intermediate decision, which is independently marked. And I would ask that complainant Tsai not interrupt the Postal Service. On those pages, the presiding officer writes, to establish a violation of 39 USC section 403C, the Commission requires a complainant to show three things. One, the complaint is receiving less favorable services than those provided to one or more postal customers. Two, the complainant is similarly situated to those postal customers receiving more or favorable service. And three, there is no rational or legitimate basis for denying the complainant the more favorable service currently being provided to those similarly situated postal customers. Likewise, on November 4th, 2024, in docket number C2024-21, complaint of Cook Coal LLC and Coal Cath Associates LLC, order number 7784 at page 11, the Commission clearly stated, quote, under the guidance set forth in Egger and the tests the Commission developed to demonstrate a violation of 39 USC section 403C, a complainant is required to show three things, end quote, whereupon the Commission stated the three elements. Immediately thereafter, the Commission made absolutely crystal clear, quote, a complainant must establish all three prongs of this test to be successful. Thus, plainly, Commission precedent imposes the burden on complainants to prove that there is no rational or legitimate basis for the discrimination they allege. This is not new or controversial law. The presiding officer should follow the law and not seek to go down an analytical rabbit hole for which there is no basis in law, and the parties to this case have not brought into issue. Regarding complainant's argument, it strains logic. For one, Tsai conflates the burden of proof on appeal as to arbitrariness and capriciousness with the complainant's burden at the hearing level. Complainant ignores the plain relevant case law I have cited in this discussion. Complainant's side then dove into the merits, deviating from the question of the burden of proof. This belies that perhaps complainant's side also knows that they have the burden of proof, and they felt compelled to make arguments which might carry a burden of proof. Complainants didn't even center their argument on the third element, instead seemingly arguing that this discussion applies to all of the elements, not just the third. The logical end result of complainant's logic is that a complainant could simply file a complaint case, and if the defendant, the Postal Service, or the respondent remains silent, then the plaintiff's arguments would be assumed. There is absolutely no basis in law in any tribunal about which the Postal Service is aware for that sort of burden of proof. Complainants argue that in some cases, there is language that the Postal Service failed to show something. Defendants can disprove elements in the course of proceedings. Those quotes are not on point. But that doesn't, whether or not the Postal Service disproved something doesn't answer which party had the burden of proof in the first instance. I'll now turn to a new point. Furthermore, Mr. Presiding Officer, based on the parties' hearing submissions, the question of burden of proof need not be central to the intermediate decisions analysis. First, complainants have failed to carry their burden. Complainant's initial brief is terse and short on legal reasoning. It's presented in an outline format. The brief contains only 2 bullet points relating to supposed discrimination against foreign blind mailers relative to domestic blind mailers. Both bullet points appear on page 1 of the brief, and in that small portion, the brief does not even clearly allege a failure of reasonableness, let alone carry the burden to establish the third element. The second reason that the question of burden of proof as to the third element of the 403C case need not be critical to the intermediate decision is that although the Postal Service does not have the burden of proof, the Postal Service has nonetheless proved that there is a reasonable basis for its policies. Again, this is not a case involving discretionary policy decisions that can be evaluated for reasonableness. Instead, as the Postal Service has explained in its briefs, the complained of differences in treatment stem entirely from domestic and international law in parameters set by foreign nations as communicated in the individual country listings, which are outside the Postal Service's control. So, in conclusion, under the plain, unequivocal law, complainants have the legal burden as to all 3 elements of the 403C claim. Detailed exploration of that legal issue is not necessary for the presiding officer to issue a decision finding no undue or unreasonable discrimination. The question of reasonableness only matters if the presiding officer were to be considering a discretionary policy decision. And that's all I have. Thank you, and I can answer any questions.
Thank you, Alex. Sai, very briefly, if you have anything on burden.
I do. May I share my screen to show portions of Order 7552?
The Postal Service would object to that. This is oral argument.
Yeah, why don't we just keep it?
I can quote it if you want.
Yeah, give me the quote. That's fine.
Sure. At page 25 of Order 7552, quote, contrary to complainant's assertion in exception 2, the presiding officer did not conclude complainant had to prove Postal Service's measurements were not reasonable. Brief on exceptions at 5. Instead, the presiding officer made a determination that the Postal Service's use, blah, 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 was both a reasonable and non-discriminatory interpretation, blah, blah, blah. The statement complainant points to was not the presiding officer adding a requirement for complainant to prove. Instead, it was the presiding officer scrutinizing the Postal Service's actions to determine whether they were discriminatory in nature, which is exactly what he is tasked by the commission to do. I agree with that sentence. And as I said, some commission statements are ambiguous, largely because they have not rested on us. Opposing counsel says that if a complaint is filed and the defendant remains silent, then this is somehow out of step with law in saying that the plaintiff's arguments will be assumed. That is, in fact, the law of default. If you file a complaint and the defendant fails to give any basis whatsoever for opposing it, the plaintiff wins. In any case involving government action, if the government fails completely to say it has any reasons whatsoever for the challenged action, complainant wins. That is true here as well. Furthermore, there is simply no way to square the Postal Service's view of the burden of proof with the decision in Gamefly v. PRC. If you have the burden of proof on appeal to show to the court on the record that there is justification, that means that you cannot rule against us without an affirmative justification. You cannot simply be silent because you will be overruled by the DC Circuit. That necessarily implies that the Postal Service has the burden of proof. This is also true in other commission precedent. And for instance, National Easter Seal Society of the USPS. This is pre-PAEA, but it said that the review has to consider, quote, absent some reasonable ground for differential treatment. Section 403C forbids discriminatory phasing of discounts, blah, blah, blah. There's affirmative burden of proof. Furthermore, for instance, our Citizens Right Mail, our 77-1, I believe, the commission expressly held that the Postal Service has the burden of proof. Our 77-1 at PDF page 204, labeled page 195, Bates 2721. 2117.
PDF, what PDF page?
Volume 1 of the opinion, PDF page 204, labeled page 195, Bates 21721. Quote, Section 403C is no different in its proscription of undue or unreasonable discrimination. Thus, the mere fact of a difference in rate among customers in the same class is not per se unlawful. What is required, however, is that some material distinguishing characteristic exist in either the segment of customers constituting class or subclass, or in the form of service to be provided such segment so as to warrant the differential. Similarly, at PDF page 202, labeled page 193, Bates 21710, which was, by the way, affirmed in National Association of Greeting Card Publishers in DC Circuit v. USPS, 1979. In that page, the commission said, quote, even assuming arguendo that CRM, Citizens Right Mail, would be a materially different service, its adoption would result in an unreasonable preference because there is no persuasive evidence upon which we could base a finding that household users of first-class mail are a special group which should qualify for a purported lesser quality service to the exclusion of other mail users. That is explicit. No persuasive evidence upon which we could base. That is the default case. Therefore, and it held that because the default failed, 403C discrimination existed. The Postal Service agrees with us that its only basis cited is strict adherence to law. Now, we agree That's if it were, in fact, strictly adhering to the law, that would be a due and reasonable basis if it were compelled by law. However, most of what it's argued, or rather, most of what we complain about, it has not even argued that it is compelled by law. As
Okay,
we will,
I
I'm sure,
got
get to
you there,
later.
Si.
So
So
agree that it does follow.
okay, I'd like to stay on burden. Is that what all you have on burden?
I believe that's everything as to Order 7784. I would ask to be able to address that later because I have not reviewed it.
I think we're going to move off this question right now. We've been going for about 30 minutes now, so I think we're going to have to pick it up. But in terms of question 2, whether Universal Postal Convention Articles 17.2 and 17.3 should be interpreted to restrict the shipping of items for the blind by letter post only rather than by parcel post. Sai, could you address that?
Certainly. So the Postal Service claims that UPC Articles 17.2 and 17.3, which give an increased weight limit for international blind mail letter post, somehow prohibit international blind mail from using parcel post. Its one sentence argument is fallacious, mistaking a permission to do A with a prohibition on doing B, confusing can with must, which it does for eligibility issues as well, which we'll get to later. Starting first, if you look at Article 16.3, it says that any item for the blind is free. If you look at 16.2 on prisoners of war, just before that, that expressly lists certain categories of item that go free for POWs, letter post items and postal parcels. Any is broader than an enumerated list and necessarily includes both of those. Indeed, UPC Article 16.2.4 limits POW parcels to 5 kilos or 10 kilos if they're via an homme de confiance. There is no such limit for blind mail in 16.3. 17.2 and 17.3 are permissive. They simply give a higher weight limit to blind mail letter post. That is an additional exemption for blind mail. Now, if you look historically, in the UPC from 1952 at least, I wasn't able to find ones before then, through at least 1995, printed papers and books used to also be in the analog articles. In 52, that was 47 articles 47, 48, 57, that was articles 48 and 49, and 67, that was articles 15 and 16. In 95, that was articles 821 and 83. Those all gave, along with the still standard 2 kilo limit for letter post generally, they said 3 kilo for printed papers, 5 kilos for books. Later, 5 kilos for books and pamphlets, later 5 kilos for printed papers. Does that mean that for that entire history, when it was listed, just like blind mail is listed exactly in the same clause now, as it was listed then, literature for the blind at the time, does that mean that you can't send a book by parcel post? No, that's just absurd. If you were to delete 16.2.3 and 16.3.2, would that mean that blind mail couldn't be sent at all? No, it would just mean that it doesn't get the 7 kilo weight exemption. If you were to add an item back, books, would that prohibit newly books from going parcel? No. And indeed, there are perfectly reasonable reasons why you might want to send something by parcel post that's allowed in letter post, like if you're sending a rare book that you want more insurance for, like the Postal Service has claimed is necessary You must send via Priority Mail Express International to get the higher rate limit from US to UK, which we can't substantiate, but they claim that. That is a perfectly reasonable basis for choosing not to use it. If you're Gamefly and you don't want something to go via machines that'll crush your item, and you want it to go parcel post because parcel post is more manually handled, another perfectly reasonable basis. If you look at the reservations to both Articles 16 and 17, other countries have made reservations limiting what can go, who can send it. UK limits parcel post weights. Australia doesn't think parcel post is a basic service. Countries know how to make reservations on this. The US has made none. So this is a weight limit which the post office, the Postal Service violates by not allowing 7 kilos for first class package international service and first class mail international parcels, if I'm remembering correctly. It is not a prohibition on using parcel post. And moreover, the Postal Service already sends international blind mail as UPC parcel post, namely Priority Mail International, which, according to its regulations, is always parcel post and is always sent using UPC parcel post labels and forms. The MCS, moreover, on all these classes of mail does not authorize any limit for blind mail parcel post. It doesn't authorize any prohibition on blind mail using parcel post in Priority Mail International, Priority Mail Express International, Global Express Guaranteed, although that's suspended. Nothing. It's not prohibited. The Postal Service is simply reading in permission to have a higher weight limit as the only service that blind mail is allowed to use. That is not the correct reading. If you have any questions, I'm happy to answer them.
Did you call my name, Mr. Presiding Officer? Okay, yes. My apologies.
Your turn, no problem.
Thank you. The question is whether UPC Articles 17.2 and 17.3 should be interpreted to restrict the shipping of items for the blind by letter post only rather than by parcel post. The answer is yes. The UPC is clear on its face. The only reading of Articles 16.3, 17.2, and 17.3 is that they restrict shipping of items for the blind to letter post only. Letter post, parcel post, items for the blind. These are all terms of art specific to the treaty. They are defined by the treaty for the purposes of the treaty only. That these terms are intended only for the purpose of the treaty is made clear by the treaty's own terms, which state at Articles 1.1 and 1.2. 1. For the purpose of the convention, the following terms shall have the meanings defined below. 1.1. Letter post item. Item described in and conveyed under the conditions of the convention and regulations. 1.2. Parcel post item. Item described in and conveyed under the conditions of the convention and regulations. As defined by the treaty for the purposes of the treaty, at Article 16.3, the term items for the blind refers to items that are to be mailed free of charge, free of postage internationally. And the treaty further defines such international free items for the blind as letter post, not parcel post. At 17.2.3 and 17.3.2, the treaty is specific that letter post includes items for the blind. This is important.
Let me just stop you right there. Wouldn't a more normal way of writing this, if you wanted to restrict letters of the items for the blind only to letter post, to flip it around and say items for the blind up to 7 kilograms are letterpost.
Perhaps it would be more normal, but that doesn't make the treaty not clear on its face for the reasons I'm prepared to discuss.
Okay. Go ahead.
Normally, letterpost items including both packets and goods are limited to 2 kilograms. However, Mr. Presiding Officer, there's an exception. Although the UPC confines items for the blind to letterpost, it simultaneously expands the usual 2 kilogram weight limit for letterpost to 7 kilograms for the exclusive purpose of items for the blind. Turning now to parcel post. Parcel post has a much higher weight limit for US origin items, 70 pounds. Nowhere does the treaty include items for the blind as parcel post. So again, notice that the treaty includes items for the blind as letterpost, but does not include items for the blind as parcel post.
Can I stop you again? Sorry.
Please.
Shouldn't this treaty specify what happens with item? Like, does the treaty at all specify what happens with items for the blind over 7 kilograms?
Yes, it limits items for the blind to 7 kilograms. And if an item is not, if it's an item for the blind, and I'll get there, if it's an item for the blind, finally, say you're sending a 17-pound package. Let's say also that the package contains an eligible item for the blind. That is a parcel post product because it's 17 pounds. And because it exceeds the weight limit for items for the blind, it cannot become a letterpost product because the UPC does not provide for items for the blind as parcel post. It is not postage free. In other words, you asked what happens with that. Well, the user pays the postage. This is not unique to the United States. Allow me then to continue my argument, if I may.
Yes, sorry for interrupting.
No, please. I am here to do this. Okay, so actually I had all three. I was getting to my examples. Let's discuss how these clear treaty provisions play out in the real world. I'll just do the first two, and then the third I'll just review. Say you're sending a 1-pound package. That's a letter post goods package. If it contains an eligible item for the blind, it's postage free. Now say you're sending a 13-pound package. Ordinarily, that would be a parcel post product because it exceeds 2 kilograms. But if the package contains an eligible item for the blind, it's postage free and letter post. Finally, you say you're sending that 17-pound package. Well, even if it contains an item that otherwise would be eligible, again, it doesn't fall within the weight limits on items for the blind as communicated in 17.2 and 17.3. Notice how in complainant's rebuttal brief, they attempt to conflate the Postal Service's use of the term, quote, parcel, end quote, in other contexts. While and the complainants did that again here at oral argument, while the term of art parcel post is used as a specific term of art in the treaty. They argue that the Postal Service fundamentally misreads UPC Article 17, and then they embark upon a strained logic reading, unique in the world to the Postal Service's knowledge. With no basis in statutory construction, complainants attempt to shoehorn items for the blind into parcel post. This flies in the face of the black and white language of the treaty. It flies in the face of logic as well. If items for the blind could be sent as parcel post with a weight limit of up to 70 pounds, why did the Universal Postal Union, in which the U.S. State Department takes part, take pains to define letter post as including items for the blind, even expanding the letter post weight limit from 2 kilograms to 7 kilograms for items for the blind only? Put another way, if items for the blind can be parcel post up to 70 pounds, then what was the point of the letter post weight limit carve out? At oral
Got
arguments,
Oh, sorry. Continue. I'll wait till you're done.
okay, I'll get there. I'll move it along. At oral argument, Tsai argues that items for the blind can be sent via parcel post. Tsai expands the definition of Article 16.3 to suggest that perhaps all matter for the blind can be sent letter post or parcel post. The logical end result of that argument, basically expanding 6.3, would be that perhaps items for the blind don't fall under letter post nor parcel post, such that they have no weight limit at all. The reservations other countries make to the convention are to free matter for the blind generally, not the weight limits thereupon. Even assuming the Postal Service uses labels and forms which might normally attend to other products, well, that makes sense because of that specific carve out for and only for items for the blind. This is these international letter post items are a drop in the bucket compared to what the Postal Service sends internationally. So yes, and perhaps it doesn't have forms unique. Regardless, that doesn't change the terms of the treaty. In summary, at 16.3, the treaty defines items for the blind. Then at 17.2 and 17.3, it defines letter post as including items for the blind. There, it also expands the weight limit for letter post for the exclusive purpose of items for the blind. But nowhere does the treaty similarly define parcel post as including items for the blind. The definitions and categories mean certain things within the context of the treaty, as the treaty makes clear at 1.2. This is not some unique reading of the treaty. It's the only reading, and it's the only one that plays out every day in the real world. It would be error for the presiding officer to read something into the treaty which is not there based on complainant's erroneous, self-serving statutory construction.
Thank you. So I guess I have two questions. The first is I do understand that there's a notion that all the other countries too are following this 7 kilogram weight limit, sending things by letter post. But can you point to any evidence in front of me on the record that I have of that?
No, Mr. Presiding Officer, I cannot. That is not an evidence. It was not clear that this was going to be a point of contention, mostly because it's just very uncontroversial.
So the second thing is I take your point, but I don't think this is a black and white issue of statutory interpretation, because I'll be honest, I've read a lot of clauses that try to define things and explain what falls into a category, and I'm not sure I've ever seen something that says if you're trying to define what items for the blind are, or saying that items for the blind are letter post, or even that letter post items include items for the blind, I can't understand why it would be written letter post items containing only documents are items for the blind. It's such a convoluted way to write something, and I'm wondering if there's any interpretive support for that, or if there's really any reason why it would be written like this.
You're on, Mr. Presiding Officer, you're focused only there at 17.2.
17.3.
Well, you said letter post items containing only documents. At
Sure.
17.2, the UPC defines letter post items containing only documents. At 17.3, the UPC makes clear that items for the blind can also be goods up to 7 kilograms.
Right. I guess my problem is not between the goods and the documents. My problem is the way that these statutes sort of transpose letter post items with items for the blind, in that they're defining letter post items as items for the blind, but they're not defining items for the blind as letter post items versus parcel post.
That's true. However, Therefore, it is silent on the issue of parcel post.
Sure.
Nowhere does the convention say parcel post items include items for the blind. Moreover, the general construction of this, what meaning does Articles 17.2.3 and Articles 17.3.2 have at all if parcel post were to include items for the blind?
Gotcha. Okay. Sai?
Presiding officer, with respect, I would just, in order that I not mischaracterize opposing counsel, I would ask him to answer three very simple questions before I respond. One, can a 1 pound package that qualifies to be sent letter post be sent as parcel post as defined by the UPC? Two, can how to phrase this? In prior UPCs, where books and pamphlets, for instance, were under the speed-based classification for letter post, did those prohibit books from being sent parcel post? And third, how does he reconcile the MCS inbound letter post, small packets and bulky objects, weight limit of 15.432 pounds, 7 kilos, that being on letter post, with the outbound version of that? So 1 pound, can it go parcel? Can books go parcel? Could they previously? And how does he explain the inbound?
I'm not going to make you respond to that. I can take it as a hypothetical if you'd like. If you'd like to respond, I'm happy to allow you time to do so.
I'll do so just briefly, and I appreciate that it was presented to the presiding officer rather than directly to me. To my knowledge, a 1 pound package is letter post, but I'm not. Don't quote me on that. So in other words, yes, it would be letter post in all instances, because it would fall under a product that would be letter post, to my knowledge. To the question of the history of this is off topic because it is clear on its face, so we don't get into the principles of statutory construction. And three, as to MCS inbound, it's totally squarable. Letter post would include items for the blind inbound up to 15 pounds, just as letter post outbound items for the blind are letter post up to 15 pounds due to the special carve out that the UPC made to make sure that items for the blind can be not just little things weighing up to 2 kilograms, but can go all the way to 7 kilograms, as we see in 17.3.2. Thank you, Mr. Presiding Officer.
Anything else before we move on?
Sure, I have actual rebuttal. So first, contrary to what opposing counsel just told you, outbound single place first class package international service weight limit is 4 pounds currently. It does not include the 15.432 pound exemption that it is required to have. That is simply a false representation. Second, 1 pound items can be sent parcel post. Priority Mail International is parcel post. It has no lower weight limit. It does not limit PMI to items that are over 2 kilos in the general case, nor to over 15 pounds, 7 kilos in the case of blind mail. That is simply not true. Next, opposing counsel constantly confuses permission, inclusion with exclusion. UPC 1.1 does define terms for the purposes of the treaty. It does not say, and for no other purposes, which is what he argued. In fact, the IMM expressly refers to UPC parcel post terms, says it is UPC parcel post for all purposes. That has meaning. You cannot label something as parcel post and then claim that by some magic it is letter post, even though literally nobody treats it as letter post, even though the Postal Service says that it can't even tell that it's blind mail because that's after the point of entry. That is not how postal operations works. Parcel post and letter post is based on the class it is sent as. The question of what happens to an eligible item over 7 kilos. Opposing counsel tried to confuse the issue by conflating it with a statement of what happens if it's over 7 kilos and it contains non-items for the blind. That's not at issue. The question is, what happens to something that is only items for the blind that's over 7 kilos? The answer is it goes parcel post. Same as books can be sent parcel post, same as literally anything can be sent parcel post that is generally allowed. If I put this in a large box and ship it PMI or PMEI, those are both parcel post. Am I allowed to? Yes. Would it be a good idea? Maybe, maybe not. I may have reasons for that, like insurance and so forth. But the fact is, I can mail this parcel post regardless of whether it fits in a flat rate box. As to the statement that a 1 pound package letter post in all instances, laughable. Frankly, that is simply not what the regulations say. As for why the UPC takes pains to define letter post in 17.2 and 17.3, if you read the very next section, 17.4 through 17.6, the 17.2 and 17.3 are classification standards that determine consequent things such as what kinds of items are accepted, what labels they use, etc. 17.2, why does it include a 7 kilo limit? Because Braille is really, really heavy. That's why. Because a Braille book is much, much heavier than a normal book. So if you're sending a Braille book, that is an item that can be sent letter post. It's only documents. It may well be 7 kilos. That in no way precludes you sending a heavier item like a Brailler or, you know, all of these, that these can't be sent parcel post. That's absurd. In fact, some of these can only be sent parcel post because, for instance, this is a fixed cane, fixed length cane. This will fit in a roll. This will not fit in a small packet. This cannot fit in letter post. There is no possible way that this will fit letter post. And the UPC does not give exemptions to size for blind items. It only gives exemptions for weight. That goes parcel post. What else did council say? Items would otherwise have no weight limit at all. That is, again, absurd. Items would otherwise have the ordinary weight limit, just like when books were removed from the ancestor to 17.2, books are now subject to the ordinary weight limit. 2 kilos letter post, 70 pounds, well, 20 kilos minimum, 31.75 kilos in the case of the USPS for parcel. It didn't mean that books, just because they're not expressly enumerated, now longer are subject to no limit at all. No, that they're not allowed to be sent at all? No. 17.2 and 17.3, the only function is to give a higher weight limit, which the Postal Service violates on outbound letter post for letter post. This is simply confusing permission with exclusion. That is fallacy.
Okay, thank you, Seth. We're going to move on to the third question presented, which is whether failure to list ground advantage in DMM 703.5.1.2 constitutes discrimination against domestic free mail for the blind users in relation to international users. Sai, go ahead.
Thank you. The Postal Service has provided no justification whatsoever, nor including not any reference to any obligation by law for its failure to list ground advantage in the DMM. It has not disputed that failure to do so is discrimination by comparison to international blind mailers. Yes, it is obviously discrimination because it is a failure to disclose. The current regulations give blind mailers no way of knowing that they can send 70-pound items by domestic mail in any way whatsoever. It also doesn't tell them what service they're allowed to use. By contrast, the IMM does list it. Ground advantage is not first-class mail, and that is the only one even mentioned in 703.5.1.2. The Postal Service's initial brief concedes that blind mail is available for, quote, the full range of mail matter, unquote, unless there's an expressly limiting law. There
So
is
1 second,
no
Si.
law. Yes.
So what is the practical impact here for domestic free mail for the blind users of not listing ground advantage, even if we know that the Postal Service is allowing ground advantage?
Sure. First, I would challenge whether we do know that. That is made by one witness who has refused to provide any documentary evidence and is directly in conflict with regulations. So I am not so sure that we do know that. A practical impact is that someone using blind mail does not know that they can send a 70-pound item, as the Postal Service has testified is to be true, again, without any documentary evidence. Another impact is under the current DMM, it says that blind mail is, quote, not considered any particular class of mail, unquote, at all. So, for instance, one of the purposes not listed in the exclusive set is acceptance. Acceptance is not processing. Acceptance is not standards of service. It's not standards for return. Acceptance is what guides the limits for weight, size, contents in general, etc. So there is no way to know what the weight limit is on any blind mail at all. The fact that ground advantage in particular is not listed is a discrimination because practically you don't know that you can send something that would not fit first-class mail sizes or weight limits that would fit ground advantage. Moreover, I would go further to say that the Postal Service has not identified any legal basis whatsoever for refusing to provide, as its own brief says, the full range of mail matter. That is to say, all classes of mail for blind mail. The 3403 does not say first class mail only. Neither does 3404. So the practical disadvantage is the same as if you were to limit anybody else to only using first class mail and ground advantage or treated as for limited purposes. That is, all the reasons that someone might choose to send something by priority mail, by ground advantage, by any other service you might care to name, which presumably there are lots of reasons because people do make that choice. Blind mailers are not afforded that option, and the Postal Service has not identified any reason for that.
Alex?
Thank you, Mr. Presiding Officer. This is the reverse of the claim at issue, which somewhat orthodoxically inquires about reverse discrimination. On September 12th of 2024, the Commission issued Order Number 7507, in which it dismissed all of complainants' legal theories but one. The Commission found the following, quote, taken in the light most favorable to them, complainants' allegations are instead that blind mail users outside of the United States are subject to less favorable, i.e. more expensive, services than those located in the United States, and that such treatment is illegitimate, end quote. On that basis and no other, the Commission found a cognizable 403C claim. It assigned the case to a presiding officer and ordered limited formal proceedings on complainant's theory of disparate treatment based on foreign country of residence. Nowhere in Order Number 7507 did the Commission give authority for the presiding officer to examine the reverse of that discrimination claim. Having explored that the answer to the question is irrelevant to this case, the Postal Service nonetheless offers this answer. No, the fact that the words ground advantage do not appear in DMM 703.5.1.2 does not constitute discrimination against domestic FMFTB users relative to international users. Ground advantage is the successor to first-class mail parcels. It has equivalent service standards to first-class mail, notwithstanding the DMM's silence about ground advantage's use for free matter for the blind. The Postal Service continues to give FMFTB treatment to qualifying domestic parcels above the first-class mail weight limits and size limits, service that is essentially equivalent to features in FCM. So it's completely unclear how this could somehow constitute discrimination against domestic FMFTB parcel users. If anything, the Postal Service is giving them service beyond what the DMM mentions. And as the Postal Service witness has attested, Mr. Kennedy, due to UPU restrictions relevant to international free matter for the blind, but not domestic FMFTB parcel mailers enjoy higher weight limits and included insurance. Cy's hypothetical argument, which Cy did not really posit until this moment, which is the reason that the presiding officer had to ask Cy the question as to actual harm, is that domestic FMFTB users are somehow unaware of their ability to send parcels due to the lack of the DMM's revision to this point. The fact that Cy does not know that domestic FMFTB parcels go as ground advantage is further proof that Cy's harm is purely speculative. Cy is not even a user of this, nor is Cy in close enough contact to know that this happens all the time, as Mr. Kennedy attested.
Cy, your response?
Sure. On that last point, the Postal Service's claim about speculative standing is squarely foreclosed by Gamefly. In Gamefly, the Postal Service similarly claimed that because Gamefly didn't use letter post, that it had no standing to complain about the availability of letter post. That was rejected, correctly so. That rejection was affirmed expressly by the DC Circuit, correctly so. The fact that the Postal Service admits that its regulations do not give mailers adequate notice of the services that it offers is per se discrimination. I will point you to the arguments made extensively by Gamefly in that case about the, what's it called? The filed rate doctrine. Although that was not adopted by the Commission because it did not need to reach that question, we would agree with the Gamefly arguments there, with the asterisk that Gamefly's argument was in the context of a commercial versus commercial situation, which is obviously not the case here. Nevertheless, For any service, if I get, for instance, a free airplane ticket, and I am not told where I can use it, what I'm allowed to bring, whether I will be reimbursed if the flight is late, etc. The things that are in the conditions of travel tariff, which are functionally equivalent. Those are common carrier provisions, exactly the same as Gamefly argued as to the Postal Service. That would be a violation of my rights as a consumer, notwithstanding that I had not paid for that ticket. I nevertheless have the right to know what service I will get. As to 7507, if you look at the footnote 19 on that exact sentence, or that paragraph, it specifically cites to granting preferences to foreign mailers over domestic ones. Moreover, the 403C scope cannot be quite so finely parsed. If the commission finds that there is a discrimination as held by Gamefly v. PRC, it is obligated to remedy it. Given that you are considering this, it is likely that you will find that that is a discrimination. I moved to withdraw and clarify the complaint. I was not allowed to do so. I agree that the complaint is somewhat ambiguous. However, as we noted in our answering brief, we did expressly plead and plead by implication both incoming and outgoing mail. When I talked about sending letters to friends, that is necessarily inbound mail if I'm located in the UK. When I live in the US, that is necessarily domestic mail. When I order items shipped to my CMRA, that is domestic mail on my ultimate beneficiary. I am the blind person at issue under the DMM. I am the one whose rights trigger blind mail, notwithstanding that I am neither sending it, as in I am not the one paying the Postal Service, and I am not physically present at my CMRA. It is still my right to send it, and I'm the one paying the postage ultimately because I pay the seller of the item. As to first-class mail parcels, they still exist. They are in the MCS. First-class mail parcels, 1115, I believe, 1115.1 first-class mail flats parcels do exist. They are currently limited to £2 for keys and identification devices. They could still be used and they could be given the £15 limit so that it harmonizes with international. And I will note that opposing counsel in response gave, again, no justification whatsoever for the Postal Service's decision, which it claims to have made no decisions at all, for its decision to limit blind mail domestically to first-class mail, or its decision to limit it now to first-class mail and ground advantage. There is simply no justification given at all. You are therefore obligated by law to find that that is unreasonable and undue.
All right. Thank you, Sai. Question presented 4. Does a certification requirement exist in the IMM? And if not, is domestic free mail for the blind disfavored because it does contain such a certification requirement? Sai, and I'd like to start you out with, pardon me?
I request a, shall we say, 10-minute recess.
Alex, is that okay with you?
That's fine.
Okay.
Thank you.
So can we meet back here at 12:20?
Yes.
You got it.
All right, great. Okay. Is everyone ready to restart?
Yes, thank you, Presiding Officer.
No
Yes.
problem. So I believe I read out question presented 4. So I would start with is there any practical impact to the certification requirement in the DMM but not the IMM? And if so, what
Yes.
evidence do I have of that?
So I'll address the practical impact. Similar to the OIG's finding in its report about the non-necessity of treating blind mail as unsealed. This is a burdensome and unnecessary regulation. Practical impacts are that it is chilling, it is expensive to obtain medical records that fulfill the precise thing that is required. The certification is incoherent even within its own text, so it excludes people who qualify. The certification requirement, for instance, citing no legal obligation at all, limits. Sorry, are you still there? Your
Yes,
camera
I'm
went
still
off.
there. Sorry, my pen ran out of ink, so I just
No worries.
got a new pen.
Your camera turned off. There's a limit on the certification for reading disabilities of who's allowed to certify those. Even though reading disabilities are often psychiatric in nature, and so a therapist who's allowed to certify other things should be allowed to certify them. That's not allowed. The certification requirement is incompatible with the law. It doesn't fully include people who are included by Marrakesh. It doesn't fully include people who are included by the UPC, visually impaired, for instance. Postmasters are not medically or legally qualified to evaluate these certifications, and they're not trained on it, as far as I know. Yet they're the ones making decisions. The certification that you're supposed to give is according to USPS Pub 718 off the top of my head. I don't recall it precisely. Says that you're supposed to give a certification to your local postmaster. I would ask, where is the postmaster for London, England? There ain't one, because this isn't the US. It is literally impossible for me to obey the certification requirement, even though I, in fact, do send both DMM and IMM mail. It causes, for instance, unqualified third parties like our CMRA to demand certification like it did from me. It demanded certification. I responded with my NLS certification. It rejected that, even though NLS certification is expressly allowed. I then, at their express demand, provided medical records to them. Even after that, they would send it blind mail. It encourages these kinds of third-party intrusive demands. Moreover, the Postal Service itself isn't complying with laws on certification. It shouldn't be keeping HIPAA and Privacy Act sensitive materials. It doesn't have a public certification form. It's never gotten approval from the Office of Management Budget under the Paperwork Reduction Act. It has a system of records notice, but those system of record notices does not comply with the Privacy Act requirements. It hasn't done privacy impact assessments. It has no need to keep these. It, in fact, isn't enforced. And in fact, it's not even possible to assess or enforce because the entity that is supposed to be blind is the ultimate beneficiary. So, for instance, if a school orders canes to use for its future students, the future student is the blind person who triggers the free mail. The school isn't blind. School isn't necessarily an organization for or of the blind, although sometimes it is. NFB has some schools, but rarely will that be the case. Similarly, for someone who's not a US resident or citizen, but is present in the US, they are prohibited. That is a confusion with subsection A of the NLS statute. It is true that NLS only serves US residents and citizens, but that's not the same as who's eligible under the Marrakesh Treaty. That's subsection G. And those people are not allowed. So all these people are subjected to these certification requirements, to imposition of paperwork burdens, which are not just fill out a form, but get a doctor to sign this, which is costly, which are reviewed by someone who doesn't know what they're looking at, which is never used. This is completely unnecessary. And if you compare to a decade of experience with the international version, under the IAMM, there is no certification requirement for a decade now. And I asked in discovery, has there ever been any abuse of blind mail? Has there ever been any blind mail spam? None. At least the Postal Service can't come up with any, which is close enough to none. And moreover, it's inherent to the nature of these things. What is a sighted person going to do with this? What is a sighted person going to do with this? This is a Braille labeler. It's got little things. You punch it, it makes Braille labels that you can apply to things. It is inherent to the nature of these things that they are for people who are eligible. The certification is completely unnecessary. If the Postal Service were to continue having a certification, then it should obey the laws. It should of the Privacy Act, Paperwork Reduction Act, APA, etc. And its certification should match the legal standard, which it does not. But given that there have been no problems with the non-certification regime in IMM, there should not be a certification under the DMM either.
Okay. And
sorry, I was muted. Go for it, Alex.
Okay, thank you, Mr. Presiding Officer. Okay, just briefly, by way of introduction to my answer, this is the reverse of the claim at issue, which somewhat orthodoxically inquires about reverse discrimination. Order 7507 says, taken in the light most favorable to them, complainant's allegations are instead that blind mail users outside of the United States are subject to less favorable, i.e. more expensive services than those located inside the United States, and that such treatment is illegitimate. Having explored that the answer to the question is irrelevant to this case, the Postal Service nonetheless offers this answer. No, the fact of a certification requirement in the DMM but not the IMM does not disfavor domestic users of free matter for the blind. Discrimination is a legal term of art, which presupposes that there would be evidence to support it. Here, there is no evidence that some mail user could not send matter via domestic FMFTB, but not international FMFTB, merely because of a certification requirement in the DMM. And there is no discrimination when there is no actual evidence of disparate treatment. So I was unable to answer the question of evidence. This is a pattern that goes to the entirety of Cy's case. It's all speculative harm, not real harm. As the Postal Service has evidenced, CMRAs have to go to the station. They have to make a trip to the post office to send things blind mail. The presiding officer should consider that fact when considering traveling mailbox as relates to the intermediate decision. While the certification requirement might add a small administrative burden on the eligible domestic FMFTB user where it's enforced, at the end of the day, the mere fact of a certification requirement does not preclude the eligible domestic FMFTB user from using that service. So I've discussed what's not in evidence. Let's turn now to what is in evidence. What is in evidence is unrebutted testimony from Dale Kennedy at page 2 of his testimony that, quote, if a customer has a question about FMFTB eligibility, the customer can discuss the matter with a Postal Service official at the point of acceptance. This applies to mailers of international FMFTB and domestic FMFTB. What is also in evidence is unrebutted testimony from Dale Kennedy at page 2 of his testimony that, quote, on occasion, a Postal Service official at the point of acceptance will escalate an FMFTB eligibility question to the Postal Service's Pricing and Product Classification Service Center. The PCSC is a national center that provides one source for mail classification decisions. It serves both external customers and field employees in need of direction on price application, mail eligibility, and mailing standards. The PCSC is domestic and international in scope. It provides guidance on mailing standards and handles customer requests for exceptions. This web page provides additional detail, end quote, whereupon Mr. Kennedy provided the URL to the public-facing PCSC webpage. Furthermore, the DMM and the IMM eligibility provisions do not reflect discretionary policy decisions and are not fit for the presiding officer's analysis in the intermediate decision. And for these reasons, the fact of an eligibility requirement in the DMM, but not the IMM, certification requirement, does not disfavor one over the other.
So what is why does this discrepancy exist in legal terms? Why is the Postal Service required domestically to include a certification requirement, but does not do it in the IMM?
Again, even if there is a certification requirement stated in one manual or another, that doesn't mean that the law outside of the manual, i.e. the treaty, does not require that international users be eligible for free matter for the blind. Admittedly, one manual has a certification requirement, the other manual does not. Perhaps the manuals should be updated, but for several reasons, this is not disfavorable to one over the other. First off, there's no evidence that in the real world, the Postal Service demands a certification in one circumstance, but not in the other. Second, there is the reality is that the Postal Service's manuals are updated all the time. Third, the manuals themselves are important pieces of the puzzle as relates to FMFTB, but they're not the entirety of the Postal Service's program with respect to FMFTB. There is the law, which is the treaty. There is domestic law. There are the customer support rulings. So there's no evidence that the DMM or the IMM, nor is there any requirement in the law that there even be a manual. The total end sum of what the Postal Service's policy is. Thank you, Mr. Presiding Officer.
Bye.
Well, that was a lot. No requirement that there even be a manual. Yes, there is 5 U.S. Code 552A1 and A2 mandate the Postal Service to publish its manuals by which members of the public are affected. Perhaps the manuals should be updated. And no evidence that in real life the Postal Service demands it in one circumstance but not the other. That is an admission of a lack of justification. If the Postal Service does not in fact demand it, and does not in fact demand it with good reason, it cannot continue a discriminatory practice. As to the very initial thing, reverse discrimination, that's called 403C favorability. 403C, let's quote, in providing services and establishing classifications, rates, and fees under this title, the Postal Service shall not, except as specifically authorized in this title, make any undue or unreasonable discrimination among users of the mails, nor shall it grant any undue or unreasonable preferences to any such user. That is exactly what opposing counsel has been calling reverse discrimination. It is illegal under 403C, and it is completely within bounds. The statement that people must be eligible, I agree with that. Yes, people must be eligible. The UPC does not allow a certification requirement, but it does require people be eligible. There are tools the Postal Service has at its disposal to enforce that. In the exceptionally rare and literally unheard of and unevidenced circumstance where someone were to abuse blind mail, it could use criminal process like mail fraud to investigate such people and to prosecute them. There is no evidence that such has ever existed or has ever happened. The claim that it's not enforced is an admission that it is not needed. The claim that I didn't answer the question of evidence, my apologies, I simply overlooked that. There is evidence, for example, our CMRA, after the Postal Service's vaunted response, after it affirmatively reached out to him, after opposing counsel personally called my CMRA and hid that on the record, and had his witness testify to it by hearsay. After all that, they did not send it to me by free mail. They sent it to me one-off via UPS or FedEx, I don't recall, and have refused to say whether they will send it free mail. Why? Because of exactly the concern that I raised in the very first instance. They think that they're not allowed to as a commercial entity. And moreover, when I said, here's my NLS certification, they said, oh, that's not good enough. Why? They didn't give any reason. This encourages this exact behavior. As for who's not allowed versus allowed, that is a question for the next QP, and so I will reserve it for that. But there are, in fact, examples of who does or does not qualify under one versus the other that go in both directions. As for the ability of the PCSC, which I had never heard about prior, and I doubt any normal person has ever heard of, that does nothing when the plain text of the regulations says you must have a certification from such and such. Your certification for reading disability can only be from these entities and not from these. You have to certify that you have a reading disability and a physical disability, though that will get into who qualifies. You have to certify at your local post office. What local post office? I'm in London. And I do send domestic mail. I order stuff in the US all the time. That's why I have a CMRA. So this justification simply does not exist. None has been cited for continuing this discriminatory practice. As for it being quote unquote speculative, it is no more speculative than it was for Gamefly. Gamefly was deterred from using the service. I literally cannot certify. My CMRA was deterred At first, by a belief that my NLS provision wasn't adequate certification. Third parties, like my students, have a right to have stuff shipped for their benefit. I buy stuff for my students. This, for instance, this is called a tandem bar. Helps when I move my cane, it moves my student's cane. This is not for my benefit, it's for my students' benefit. So these certification requirements, although I have never completed one, in fact, I have not once given the Postal Service any certification. They are chilling. They are completely unnecessary. And because they lack any reason, they must be considered 403C discrimination or favor, as the case may be.
Okay, let's
Preference.
move on to the last. Sorry, I was just going to say let's move on to the last question presented. Is the DMM more restrictive in its eligibility requirements than the IMM? And if so, does this constitute unfavorable treatment of domestic FMFTB users in comparison to international counterparts? Sai.
First, I have a clarifying question. Do you want me to talk about eligibility of a person or eligibility of items?
I'd like you to talk about eligibility of a person first, and then you can move on to what you'd
Excellent.
like. We've already run over. If anyone has any time deadlines, let me know.
I'm fine.
Thank you.
So gladly. The Postal Service has given no justification other than a false allegation of compulsion by law for imposing more restrictive eligibility requirements both in the DMM and in the IMM. Its regulation and its briefing demonstrate a profound ignorance of and hostility to disability issues, and its regulations show an inability to even just copy and paste perfectly clear definitions that are found in the UPC and the Marrakesh Treaty without introducing confusion and legal error, resulting in a restriction of both domestic and international blind mailer qualifications by comparison with each other. I will also note, incidentally, that qualification here includes qualification for services. The DMM says a blind male isn't eligible for any ancillary services except insurance. The IMM says only registered or insurance. There's no justification for why it won't sell registered domestically, nor for why it won't sell tracking, return receipt, etc. in both. Those are also eligibility as a formal matter. So as for the difference between these requirements, this is a fundamental misunderstanding by the Postal Service encoded in its regulations between two very different things. The Marrakesh Treaty, which is copied verbatim in 17 US Code, referenced in 2 US Code in the NLS provisions, in turn referenced in 3403 and 3404, which in turn references 3403. The Marrakesh Treaty is for people with reading disability, or more accurately, a print disability. It has 3 separate prongs. One is someone being blind. The second is a reading or visual or perceptual disability. And the third is a physical disability or a disability of eye movement or eye focus that impairs reading. The UPC is blind as defined in international law, which means blind or low vision, or sight impaired or visually impaired. These are roughly synonymous terms. So by way of example of things that don't really match this overlap, and then I'll further go to eligibility that isn't an issue of those. Let me, where did I put my list? Yeah. For example, someone who's not blind but low vision, cataracts, age-related macular degeneration, glaucoma, diabetic retinopathy, presbyopia, migraine, like I have. Someone who may be blind or visually impaired, but not necessarily Marrakesh reading impaired. Someone with night blindness, like one of my students, some forms of CVI, cortical visual impairment. Someone who's night blind can't see the ground in front of them at night. They can see just fine in good light. They need to use a cane. They don't need audiobooks or Braille. So they qualify under the UPC, but not necessarily under Marrakesh. Someone with a Marrakesh impairment, but not necessarily blind or VI, some forms of migraine, less severe than mine, farsightedness, perceptual abilities, other forms of cortical visual impairment, reading disabilities, dyslexia, which is not a physical disorder, physical manipulation. There's spasmodic torticollis, tic disorder, functional movement disorder. Those are non-organic. Organic includes quadriplegia, arm amputation of a vet, which is, by the way, given special preference in 135B Title II. Multiple sclerosis, Parkinson's disease, stroke, shrapnel injuries of vets. Again,
can I stop you?
Disorders of physical. Yes.
Right now, I'd like to try to keep us contained to the DMM language versus the IMM language in terms of the eligibility requirements, if we can.
And this is in the language of DMM versus IMM. DMM includes, by reference, Marrakesh qualification, expressly includes that via the NLS. All that limits to only people who are served by the NLS, which means citizens and residents. But anyone who's Marrakesh qualified is qualified under the DMM. The IMM does not have that inclusion. The DMM does not have the inclusion that's in the IMM of low vision. These are different sets of people. Someone can be visually impaired or low vision and not have a reading disability, and vice versa. So further to the differences between low vision and Marrakesh, there are the fact that DMM excludes mail to or from organizations of the blind, other than its one carve out for NLS materials. There are non-NLS blind libraries. In fact, I'm a member of one. Here's a DAISY CD from the German Library for the Blind. I'm a member of it. There are Germans who live in the US and get mail from there. ACB, NFB, etc. They have local chapters. Most people who train blind people, that's called orientation and mobility instruction by rehabilitation specialists. Almost all of them are sighted, not blind. There are a few who are blind, like me. Not technically, I'm a specialist. DMM, unlike IMM, excludes letters from sighted to blind. That is a misreading of 3404. 3404 is limited to letters from the blind, but 3403 is not. It includes reading material. IMM allows it. DMM excludes it. DMM excludes non-US residents and citizens. The IMM does not have that exclusion. Both the IMM and UPC and DMM, I should say, exclude items that have advertisement or that are for profit. Profit is a qualification of, I suppose, the sender or the recipient, or who knows, some eventual person in the nether. That is not in the UPC, and it's also not in 3404. That's only in 3403. And 3403 does not compel the interpretation that the Postal Service has used, which in fact is rather more restrictive than the legislative record shows was intended. Um, in fact, the Postal Service claims that the IMM doesn't restrict for-profit entities. USPS Exhibit B, the emails that it sent to our CMRA, Bates 65 and 66. The CMRA says that it has a concern with being able to use international because it is for-profit or commercial. USPS responded, there is no restriction on for-profit entities availing themselves of free international postage under the IMM's provisions on international free matter for the blind. That simply does not square with the plain text of IMM 272.3b, which says that the following list is not inclusive, but provides guidance about ineligible items. The item is intended as a profit-making transaction. Despite the Postal Service's communications, or possibly because of them, and in fact opposing counsel's personal communications, which are should be in evidence and are not. Nevertheless, our CMRA was convinced that it was not allowed to send it, even after the Postal Service's vaunted PCSC and so forth. It got direct clarification from opposing counsel, and it was still convinced that it was not allowed. And I think rightly so, because that is plain in the language of the regulation. So all of those entities are prohibited despite no basis in law. What it should be is simply copy and paste Marrakesh and UPC eligibility definitions. Physical impairment is a separate thing from visual, etc. Copy and paste them in both, join them with an or the end.
Okay, Alex.
Okay. Just briefly, again, my little preamble. This is the reverse of the claim at issue, which somewhat orthodoxically requires about reverse discrimination. Order 7507 said, taken in the light most favorable to them, complainant's allegations are instead that blind male users outside the United States are subject to less favorable, i.e. more expensive services than those located in the United States, and that such treatment is illegitimate. Having explored that the answer to this question is irrelevant to this case, the Postal Service nonetheless offers this answer. No, even assuming that the DMM is more detailed in its eligibility provisions, this does not constitute discrimination against domestic users of FMFTB. This answer reflects the public representative's logic. While the public representative discussed supposed disparity in clarity between the two manuals as to eligibility requirements, the public representative also went to lengths not to characterize such a disparity as discriminatory. Furthermore, supposed eligibility problems encountered by domestic users relative to their international counterparts are not facts in evidence. Regarding personal eligibility as opposed to item eligibility, notice that size CMRA was asking for certification for an international FMFTB user. Notice too that the CMRA is not the Postal Service. There is no basis in law to impute the CMRA's acts or omissions to the Postal Service. What is in evidence is unrebutted testimony from Dale Kennedy at page 2 of his testimony, discussing that if a customer has a question about FMFTB eligibility, the customer can discuss with the Postal Service at the point of acceptance, not a CMRA. This applies to mailers of international FMFTB and domestic FMFTB. What is also in evidence is Dale Kennedy's testimony about the PCSC. Once again, this case is about whether international FMFTB is somehow treated worse than domestic FMFTB, not the other way around. And as we attested, and as the PR acknowledged, international FMFTB eligibility is not treated worse than domestic. The PR acknowledged this in so many words, and it is telling that the PR did not even see fit to file a rebuttal argument after having seen the party's initial hearing submissions, nor did the public representative even see fit to take part in this oral argument today after having seen the party's rebuttal submissions. Thank you, Mr. Presiding Officer.
Okay, Cy, brief response if you have anything.
Sure. On the initial part, same response as before. Second, if the DMM is more detailed, that isn't discrimination against domestic. Well, it is a preference for domestic against international, in that it includes people partially who qualify under Marrakesh. And as for the PR's logic, the PR specifically said that he was not very well versed on issues of disability. He did not know about light blindness or CVI, nor did he seem to understand the difference between the standard of blind or low vision versus the standard which traces to the Marrakesh Treaty reading disabilities. Someone who is light blind does qualify as low vision. They do not qualify as reading impaired. As for facts in evidence, as the presiding officer held, this case is one that depends almost exclusively on law. Facts in evidence include the regulations. The regulations are discriminatory on their face. No one needs to prove that they personally were prevented, because it is the text of the law that is being challenged. We are not like many other cases. This is not a dog case. We're not saying the Postal Service wouldn't trim my hedges because I'm old, like another case had. This is a case about the regulations themselves. We do not need to prove more than what the regulations say. As for there being no basis to impute to the Postal Service the CMRA's actions, in fact, given opposing counsel's unethical behavior in failing to disclose his contact with our CMRA, you
Objection.
must take an adverse influence. You must.
Yeah, just for the record, no one has found that Alex's behavior is unethical.
Alex contacted our CMRA directly. He failed to disclose that in response to POIR 1, which required the Postal Service to disclose all contacts between the Postal Service and our CMRA. He talked personally with our CMRA. I have not been given any opportunity to determine what he said to them. For all we know, and you must assume, he convinced them not to. Moreover, the regs themselves are disfavored, are read reasonably by our CMRA as prohibiting them from using blind mail. Even after opposing counsel keeps referring to the PCSC, you can ask the PCSC for clarification. They can't override the regulation, and whatever the best possible clarification could have been is what opposing counsel and the Postal Service gave to our CMRA specifically in response to a complaint, in response to conferral. And they could not convince our CMRA that our CMRA was allowed to use it. Why? Because it is clear from the regulations that they are not. There is no justification for that. There is nothing to be deduced from the fact that the public representative didn't participate in oral argument. He thought he didn't have more to contribute. That is all. Let me check if I missed anything. Yes. Another aspect, if the DMM is more detailed, well, it is more detailed in both orientations of discrimination. For one, it includes statuses that the IMM does not, such as reading disability. And for two, it excludes conditions that the Marrakesh Treaty requires to be included, like dyslexia, which is a non-physical disability of reading, and it includes a vet who's had his arm blown off, which is a purely physical print disability, not a reading disability, but rather a disability having to do with being able to hold a book that is explicitly qualified under Marrakesh. It's not allowed by the DMM. If you have no further questions, I believe we can move on.
Okay, so those are all the questions presented I have. We're already way over time. So I can give both parties 10 minutes each if they'd like to address any other issues that I haven't already addressed.
Sure. So on item eligibility, the DMM and IMM standards are not identically worded. The IMM, unlike the UPC, excludes the provision of material being in whatever format. The IMM, unlike the UPC, excludes devices that were made for the blind, like this, as opposed to ones that were adapted for the blind. The IMM, unlike the UPC, excludes advertisement and profit. The DMM, unlike 3403 and UPC, excludes items made, not adapted for the blind, excludes items adapted for visually impaired or print disabled. DMM, unlike 3404, in letters from the blind, excludes advertisement and profit. The DMM, unlike the IMM, prohibits letters from sighted to blind. Yes, 3404 doesn't cover that, but 3403 does. It's reading matter. Furthermore, the Postal Service has not given any justification at all, nor even claimed to be legally obligated, because it cannot claim to be legally obligated, for its refusal to offer all mail classes and all ancillary services ordinarily offered on those classes of mail to blind mail. The IMM includes registered mail, DMM doesn't. Why? No reason at all. Neither of them allow tracking, even though it is unrebutted evidence that tracking is in fact a very significant issue for blind mailers. Why? No reason at all. 3404 does have a unsealed provision. 3403 does not. The OIG's report specifically investigated that and concluded that the unsealed provision was costly and pointless and should be removed unless they had a good reason to. Postal Service promised to do so, or to review it rather, by 2023. There's no evidence for what their answer to that was or why they continue doing it. Let's see. A small point, but pertinent to the question of having to publish your regs. In IMM 272.5, it refers to Administrative Support Manual 274. The ASM is not published, although it is required by law to be under 5 U.S. Code 552A2. by virtue of it being unpublished, according to that code, nobody may be required to make use of it or to be adversely affected by it. Let's see, what else have I not covered? Let's see. I will give a couple examples of items. This is a playing card deck with jumbo index. These are adapted for blind or visually impaired, not for reading. This is an example of one further adapted. It's got Braille. These are not allowed in one, allowed in the other. Another item made for, what is this? This is a cane clip. It's to put on your cane so you can hang it on a table. Allowed in one, not in the other. Braille labeler, allowed in one, not in the other. Glasses, these are for someone with migraine. These are actually welding glasses, but they're repurposed. Allowed in one, not in the other. Goal ball. This is allowed in one, not in the other. The Postal Service dismisses blind mail as being a minority of mail. Yes, it is a minority of mail. Nevertheless, it represents 19 million pieces a year, for which Congress pays the Postal Service about $50 million a year. Maybe we are small by comparison to direct mailers or other entities that the Postal Service cares more about. That doesn't mean we don't have the same rights to full treatment, full service, full access to all the services the Postal Service offers. The Postal Service has a responsibility and authority to determine how to obey the law. In this case, however, it has expressly admitted that it has no justification whatsoever for almost everything. You heard opposing counsel say that they had no reason for the certification difference, that in fact they don't use it. You heard opposing counsel fail to give any reason for refusing to provide tracking services, for refusing to provide priority mail, for refusing to provide Priority Mail Express International, on which they could charge air surcharge. For the exact provisions of the certification of eligibility, like the provision that a reading disability is only certifiable by a limited set of people. These simply have no basis in law. No matter how deferential you are to the Postal Service, you cannot defer to a lack of reasoning. And that is expressly what the Postal Service has argued that it has done. It expressly says that it made no policy determinations, that it has no authority to make any, that it has no discretion here. We agree with it in part, in that it does in fact have no discretion to depart from the provisions of the treaty. It nevertheless has done so. It nevertheless has departed from 3403, from 3404, Marrakesh, and UPC. All of those are discriminatory, or to use opposing counsel's term, reverse discrimination, i.e. 403C preference, which is illegal. I've provided a few examples about qualification standards not being the same, and there being examples of things that are in one qualification and not the other. However, I agree that that has not been fully briefed. What our burden is to show is that there are similarly situated groups and that there is preference or disfavor between one and the other. We have shown that. I would ask the presiding officer to reserve his decision about exactly the nature of that discrimination and the details of it, because that is something that needs to be negotiated as a question of remedy. So we would ask the presiding officer to hold that the DMM doesn't match the IMM doesn't match UPC or Marrakesh, DMM doesn't match 3403, 3404, Marrakesh or UPC, that there is therefore discrimination or preference among users of the mail. I would ask him to explicitly hold, to clarify commission precedent. The Postal Service has the burden of proof to show what its reasons are and to show that its discriminations, our preferences are both due and reasonable. To hold that the Postal Service has failed to meet its burden of justification, to hold that, as held by Gamefly v. PRC, the Commission is obligated by law to remedy all discrimination and preference that it has found, and to preserve the details of that remedy for further negotiation and, if necessary, briefing. Thank you very much.
Thank you, Sai. All right, Alex.
Okay, I'm going to move quickly, please, Mr. Presiding Officer. So it'll all be on the transcript of this, if there is a transcript.
No problem.
At oral argument regarding presiding officer's question 2, the presiding officer expressed a concern that the UPC is not clear on its face. While the Postal Service's position remains that the treaty is clear on its face, if the analysis proceeds to principles of statutory interpretation, those principles support our argument. Sometimes dubbed the rule of harmonious construction, statutory provisions must be read to be consistent with each other. Thus, even as Article 16.3 says, any item for the blind sent shall be exempt from all postal charges, this must be squared with the rest of the treaty. Therefore, because the term items for the blind is later defined in 17.2.3 and 17.3.2, that definition must be read consistently throughout the treaty. We can conclude that items for the blind are limited to letterpost for both documents and goods. This adds to and is read harmoniously with the discussion in Article 16, where Article 16 primarily just conveys that items for the blind are free. Moving on to my general presentation, this is a case about complainant Sai, who speculates without any proof whatsoever that Sai, and maybe Sai's own legal entity, which is the only other complainant, has fallen victim to some grave injustice associated with free mailing privileges. Because complainants adduce absolutely no proof to support their theories, and because the Postal Service has disproved any supposed discrimination, the presiding officer should issue an intermediate decision in the Postal Service's favor. The Postal Service's initial brief should serve as a roadmap for the forthcoming intermediate decision. Starting on page 6, the Postal Service explains that the 3 complained of differences between domestic and international FMFTB, about which the complaint reasonably put the Postal Service on notice, flow from governing law or conditions set by outside entities. First, the weight limit differences in weight limits are not unique to FMFTB and or reflect governing law. The initial brief covers this at page 6 through 8. Second, the complaint of difference between domestic and international FMFTB, about which the complaint reasonably put the Postal Service on notice, is insurance availability. The initial brief covers this at pages 9 through 11. Third and finally, the complaint reasonably put the Postal Service on notice that complainants claim that there are content restrictions on international FMFTB, which may not be present on domestic FMFTB. Each of these 3 things, weight limits, insurance availability, and content restrictions, are beyond the Postal Service's power to decide. So, with respect to 403C, the legal analysis is that either these things go beyond the Postal Service's discretion and are thus not actionable under 403C, or that because the Postal Service, or that because the Postal Service has no discretion, its policies are not unreasonable, which defeats the third element. Beginning on page 12, the remainder of the Postal Service's initial brief discusses how complainants cannot show undue or unreasonable discrimination. First in this section, the brief discusses Ambutech. The complaint made a lot of hay about Ambutech. That word appears 21 times in the three-part superseding amended complaint. A critical moment in this case came when, on January 14th of 2025, Ambutech responded informally to the presiding officer's information request by stating that they're a Canadian company and they don't want to be involved. Also on the topic of Ambutech, the Postal Service's brief discusses how at page 11 of the complaint, complainant Tsai insists that Ambutech's cane repairer was supposedly, quote, perfectly willing to mail a cane to the United States via FMFTB. Then, in discovery, complainants disclosed an email where the cane repairer lists shipping costs to all three of Calgary in Canada, Boston in the United States, and London in the United Kingdom. The brief next discusses how complainants have failed to prove complainants' assertions about disparate treatment as regards mail piece contents. Unanswered yet as yet is who tried to ship something via international FMFTB but was denied by the Postal Service. From where? To where? What was the item? When did this happen? Counter to complainants' hypothetical scenarios, in reality, the Postal Service routinely accords FMFTB treatment to eligible international items, as Dale Kennedy testified. The brief next discusses how complainants' discussion of the National Federation for the Blind is unavailing and raises a credibility question. The brief discusses how the NFB catalog notes that domestic blind mail delivery is substantially slower than first-class mail. To the contrary, the catalog actually states, quote, most of the time, free matter for the blind shipments are delivered by the Postal Service within the United States as quickly as first-class mail. Complainant's second supplemental declaration of Tsai tries and fails to rehabilitate the witness by discussing that the NFB catalog also says that shipments are not priority mail and could be delayed. But that doesn't explain why in the complaint Tsai wrote that NFB's catalog notes that domestic blind delivery is substantially slower than first-class mail, where the catalog actually says most of the time free matter for the blind shipments are delivered by the U.S. Postal Service within the United States as quickly as first-class mail. Complainants' less than candid representations to the words of third parties don't stop there, as the brief next discusses how complainants' discussion of a werewolf gear also raises a credibility question. I'll just briefly touch on this one, which is readily apparent in the initial brief, which is essentially that complainant Tsai said that a werewolf gear does not ship via FMFTB for one reason, while omitting what Sedona Dave said in his email, that Sedona Dave doesn't like to use FMFTB for his own personal reasons. He doesn't like to feel victim-y or entitled. Here again, Tsai's rebuttal testimony tried and failed to rehabilitate the witness. There, Tsai insists that the complaint was only talking about the primary reasons a werewolf gear does not use FMFTB. Never mind that in the black and white email, Sedona Dave did not flag any of his reasoning as primary or secondary. Finally, the Postal Service's brief touches upon the reasonable steps it took to assist Tsai with Tsai's CMRA issue, not Postal Service issue, before the complaint was even filed. Let's discuss now the public representative's brief. If undue or unreasonable discrimination were apparent in the party's voluminous discovery disclosures, the PR might well have said so. Apart from the policy considerations the Postal Service might owe to the PR's suggestions, which, by the way, essentially are the entirety of the complaint, which is that maybe somewhere someone's suffering something hypothetically if this policy is the way that it's written. The suggestions that the PR brings are extraneous to the pled discrimination claim before the commission. Furthermore, the public representative declined to submit any briefing, reply briefing, that is. And furthermore, even after viewing the party's initial rebuttal submissions, wherein the Postal Service discusses the PR's brief, the PR declined to participate today. Turning to complainant's initial brief, It was mostly presented as an outline. It's only on topic on page 1 where it addresses supposed discrimination against foreign blind mailers. The first Romanet appears to assert that a limitation against commercial blind mailers that supposedly does not exist against domestic blind mailers. As a matter of statute, though, the no profit-making condition applies to all domestic origin FMFTB items, domestic and outbound international alike. This is all discussed in the Postal Service's answering brief. The second Romanet I points to differing weight limits between outbound international and domestic FMFTB. We've discussed that at length here today. Remember, Mr. Presiding Officer, that the hearing matters. There are a lot of pleadings in this case, but the presiding officer set rulings that said, this is the time you submit your evidence. This is the time you submit your actual hearing arguments. In the course of a proceeding in litigation, there is the trial, and then there are things extraneous to the trial. In the trial, complainant did not prove their case, neither did they elsewhere, but all we're focused on here are the hearing submissions. Complainant's hearing exhibits were mostly not disclosed in discovery. But the Postal Service declined to file a motion to strike on that because they don't do anything for the complainant's case. Let's turn now to the various rebuttal submissions, and I'm running out of time. They likewise did not disclose the rebuttal exhibits in discovery. All along, complainants knew that they need to try to play a gotcha game, and they knew that they needed to muddy the waters. They had to fish for it. It didn't work because there's nothing there. And in conclusion, the legal analysis here is simple. Complainants have failed to prove their case. The Postal Service disproved complainant's case, so the presiding officer should issue an intermediate decision finding no discrimination. Thank you, Mr. Presiding Officer.
Thank you, Alex.
May I have 2 minutes just to rebut a couple of the statements?
You can have 2 minutes.
Thank you. Opposing counsel claims that items for the blind are defined in 1623 and 1632. If that were the case, we might agree, but they are not. Just like in the previous versions of that exact provision, which included books, 1623 and 1632 do not define items for the blind as being letter post. They do the exact opposite. This is a fallacy, confusing a contrapositive with a converse or an inverse, I'm forgetting which. As for domestic versus international insurance, the Postal Service has not provided documentary evidence that it is in fact obeying any restriction from the UK, but even supposing it is, that problem is traceable to the fact that it doesn't allow all the classes of mail for blind mail, like PMEI, which it said would provide more insurance. There's no justification offered, despite repeatedly being challenged in this argument. There's no justification offered for restricting what classes are offered. We agree that it does not have the authority to depart from governing law. Nevertheless, it has done so. As for the Postal Service making a big deal about Ambutech, the complaint explicitly said I talked about Ambutech because it was simply the one I know most. This is an NFB cane. In fact, it's the one my CMRA refused to ship me after the Postal Service failed to convince them otherwise. This isn't a werewolf cane. They are very similar to this, which is an Ambutech cane. Makes no difference. As for being willing to ship, that is answered by Gamefly. They're prohibited by regs from shipping because they're a for-profit company. So the fact that they don't use it is not evidence that they're not willing. As for slowness, the NFB says it's slower. Carroll Center says it's slower. A werewolf said it's slower as his first thing he said after he said what he personally feels. We've said it. The OIG said it. USPS has given no evidence otherwise. As for the claim that 30.403's restriction on profit and advertising applies to every domestic origin mail, A, no, it doesn't apply to 3404 expressly by 3403A. And second, no, it does not apply to the UPC. If you look at the regulatory record in the postal bulletins and in the Federal Register, every single time the Postal Service has made any change to international regs, it's cited the UPC only, not 3403.
Thank you both. That was very nicely argued, both of you. So before we conclude, I do have a question for the Postal Service. Just based on my schedule, I'm going to be out the next couple days. So I wanted to know if the Postal Service intended to file, in terms of the motion for access that Cy filed, an extension of the non-public status under CFR 3011.401C.
Allow me to look at that.
No problem.
Add it up. Oh, there it is. C. Well, the Postal Service, if we're talking about the Postal Service's response, it already opposed complainant's motion. My apologies for not knowing what you're asking about, Mr. Presiding
No,
Officer.
that's okay. I understand.
I believe this is in reference to Gamefly, whether, since it's older than 10 years, whether the Postal Service think it should still be protected.
So this is the, yes, this is the 3011.41C extension request.
I'm on 301. Allow me to go to 401. I was on leave earlier this week, so
Yeah,
I do
totally
defer to my
understandable. Yeah, I
colleague,
know you're
Robbie,
sure.
on this question. I'm getting to 401. 401C.
Yeah, I'm getting there too. I would, I mean, insofar as it's connected to this proceeding, I think we would have grounds to oppose, but I mean, otherwise, I think what I would say mostly is that it's just separate. The Postal Service position is that is separate to this proceeding, especially now, given the requested access was for oral argument. We've already hit oral argument. I think I'm not ready to say on what grounds we would oppose generally in a general request, but insofar as access would be granted pursuant to this proceeding, we might oppose.
I would add that it seems to me that the presiding officer does not have authority to rule on this motion. Rather, only the commission does under 3011.301.
With respect, 3011 400 motion is ruled upon in the ordinary course. The Postal Service has a 7-day limit to affirmatively apply for protective order being continued in general. And it also has an affirmative duty to object to us getting the materials under protective order. It has done neither. If it does not do either by 7 days after the motion, you are required by law to grant the motion.
Presiding Officer Press,
You have no
could I briefly ask if you're asking this in the context of this proceeding? Because that it really does change who works on it in terms of postal and
So
the grounds
I
that
am
we would-
asking in the context of the motion for access.
Oh,
And in the terms of the motion for access and the supplement, which the supplement was filed on the 17th, I believe,
mhm.
whether or not the Postal Service intends to file the extension of the non-public status under 3011.401C, which
Mhm.
I think by the plain language of that regulation says that the extension would be due today at, by the end of the day. So if
Gotcha.
the answer is the Postal Service doesn't know if they're going to file an extension or not, or doesn't, whatever your answer is fine right now. I just wanted to see, because it might affect when I rule on this motion for access, and I'm going to be
Gotcha.
gone tomorrow and Monday and Tuesday.
Okay, well then I guess the answer I would give you is that at this time I cannot say for certain what we're going to do in terms of opposition, but you will have our response by 4:30 if there is one.
Totally understood. Thank you.
I will give an offer, which is I will consent to the Postal Service moving for an extension of time to, I forget when you said you're back, to that day, end of day, since they have not briefed it. Although, in fairness, I don't think that they're entitled to an extension, and given that they have not filed for an extension, non-public status, it expires. But if they want it, I will agree to extension until whenever you're back, presiding officer.
I appreciate that. Just for your guys' knowledge, I'll be back on Wednesday, so I'll be in the office Wednesday.
Okay,
Yeah,
so
I mean-
I take it then that we have until next Tuesday to file. Is that correct?
If you
that
ask for
doesn't
it.
change the regs.
Yeah, I'm not in the
Correct.
business of turning down extensions, so I mean, if that's something that you're willing to give us, then sure, I'll take that time. But yeah, I think there are a few questions that I would like to have researched some more before I say for certain whether or not we're going to it. Including whether or not what we filed in opposition already suffices, but we will.
Totally.
I think we can all agree here. Seems like there's, group agreement that we will defer that decision until 4:30 p.m. on Tuesday.
And because this is in the reg, the timeline is a regulatory one. The Postal Service would ask that the presiding officer issue a POR that says we have until next Tuesday. Or is that something that the presiding officer will just take notice later?
I think I can do that retroactively.
Thank you.
I would ask, given that they seem to intend to file a very different response, I would ask for leave to reply.
So I just
Within,
need
say,
to see.
one day.
Right now, it's hypothetical. I sort of need to see what is being talked
If
about.
they file it.
Sure.
If they file it, I would like to leave.
Why don't the Postal Service file? I'm confident we could get a motion for extension in by 4:30 today, so that we have something on the record that you may.
I'm satisfied with Mr. Press's assurances. Thank you, Robbie.
Would the Postal Service stipulate, as I agreed to an extension, will the Postal Service agree to me being allowed to file a reply?
We don't even know whether we're going to file anything, and no.
If you file something.
No, you've very kindly given us an opportunity for extra time, but that doesn't mean that we are going to change. That doesn't change the substance of the thing. Okay, so where I view you're giving us a sort of procedural favor, we're not going to concede a substantive one. Thank you though. For real.
Didn't ask for
Appreciate you.
Just a procedural one, leave to reply. That's all.
Thank you.
Okay.
The last thing
presiding
I will
officer, I request that.
the last thing I'll say is, if there is interest by both parties, I'm happy to sit down once more for another settlement talk.
We are
But
interested.
That's obviously, I just wanted to put that out there. All right. Well, thank you all. I mean, that was again really well argued. I appreciate it. So
Thank you very much.
I'll talk to you later.
Thank you.
Good evening.